Hello everyone and welcome to Digital Media Law. This is a lecture for Journalism M02, Digital Media Reporting and Writing at Moore Park College, and my name is Professor Kelsey Stewart. So we're going to go over a series of questions really quick just to kind of test your knowledge. So I'm going to give you a couple scenarios. First one, you are the online editor of your campus newspaper, and a person using a pseudonym has posted a message on your website that could be libelous. If you don't remove the posting, the paper will be liable for the information in the message if a lawsuit is filed. True or false? So this is false. The paper is not liable for a message posted by a third party. The Federal Communications Decency Act grants immunity to website operators and internet providers for messages posted by a third party. But if you create part of the message by editing it, you could be considered a content provider and you would be liable in a lawsuit. In addition, because the web is a global medium, you could be liable in other countries. It's a good idea to check the posting and delete the ones that you think are offensive or potentially libelous. So, libel is a false or defamatory attack in written form on a person's reputation or character. Oral or spoken libel is considered slander. In the New York Times versus Sullivan, 1964, a group attempting to raise money for the Committee to Defend Martin Luther King advertised in the New York Times with a statement saying Martin Luther King had been arrested 7 times and his house bombed. They also accused the police in Montgomery, Alabama, for police brutality against black students. The police commissioner, L.B. Sullivan, sued for libel. If the answer is yes, it's basically libel. So think about it. If it is a false or defamatory attack, then yes, it's libel. Are you publishing something that may not be truthful, or is it inaccurate? Something that is accusatory? Is it harming a person's identity and reputation? Yes, it's libel. So here we have another test your knowledge. You have visited a campus website that has a graphic you want to use in your campus newspaper or your radio station's website. The site does not contain any copyright notice, so you can use the graphic without permission. True or false? The answer is false. All material on the internet is copyrighted as soon as it is created. It does not need to have a copyright notice to be protected by the U.S. copyright laws. However, some images may be available without permission if they are from most U.S. government sites or from websites that say permission is granted for specific use. In many cases, the site may grant permission to use images on personal pages, but not for commercial use. Here's another one. Test your knowledge. Any columns labeled opinion or editorials published in your newspaper cannot be considered libelous regardless of the information they contain. True or false? The answer here is false. You may express opinions without impunity, but if you publish an allegation that is false and damaging to a person's reputation, you can be sued for libel no matter where it is published as a newspaper, on a website, or in a broadcast medium. You can criticize someone as a bad performer without being libelous, but if you falsely accuse the performer of being a drug addict, that would be libelous. Test your knowledge. You are posting a video on YouTube. If you use a portion of a popular song in your video, you will not be violating copyright laws. True or false? The answer here is false. You are violating copyright by using all or a portion of a song or video that you did not create yourself. The YouTube site specifically states if you are not sure if something will violate someone's copyright, the safest thing to do is to create something completely original with images and audio you've created. Don't post something recorded, or downloaded without permission. Know your limits. Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise of thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. This is the First Amendment. Know its limits. Know your limits. Oops. The Federal Communications Commission regulations and free speech. One of the biggest questions in media law is the question of federal regulations and the constitutional limits of free speech. Even though the First Amendment to the United States Constitution guarantees an individual's right to free speech, there are limitations on broadcast speech that the Federal Communications Commission considers obscene. In 1973, Miller versus California case, the U.S. Supreme Court said that there are obscenity limitations to the free speech in broadcast media. The FCC continues to regulate speech in free-to-consumer broadcasting like radio and television. Internet content providers, satellite, and cable providers don't have corresponding limitations. The FCC, though, may issue fines for words they consider obscene. In 1978, the Supreme Court confirmed the FCC's power in this regard. FCC and violations and fines. Another example of FCC content regulation is the fine that the FCC levied against CBS for content broadcast during the Super Bowl halftime show. In the case, MTV blamed Janet Jackson for acting without authority when she exposed her breast during her halftime performance with Justin Timberlake. Because of the outrage following the performance, the FCC increased fines for a violation from $27,500 to as much as $325,000 for each violation. Media law is defined as law that regulates media production and use. Media law can encompass many different types of media, including broadcast television, internet, and print media. The practice of media law may involve all types of legal issues that might arise during the production or consumption of various types of media. Separate but not equal. The government treats different types of media very differently when it comes to regulations and oversight. Broadcast media actually has the greatest amount of regulation. Broadcast media is the media that it's intended for a general audience and mass consumption like radio and basic television. By contrast, subscription radio and the internet have far fewer regulations. There are separate types of media lawyers. A media lawyer who works in film might have their clients with option agreements, distribution contracts, and issues with talent. Multimedia lawyers may need to work on software licensing or sale regulations. Attorneys who practice media law need to understand their client's business in order to understand legal advice that's pertinent to the type of media involved, which is a law that protects witnesses from revealing certain information, especially in court. While most states offer a law to protect reporters from revealing their source if a case comes to court where testimony from the source is needed, but the actual federal shield law. So the shield laws are per state, not per obviously not as a federal law. The California shield law, it has a reporter's privilege embodied into both the article and the Constitution. The California Supreme Court has interpreted these shield laws to give broad protection to reporters. California courts have also recognized a reporter's privilege under the First Amendment. In addition, in response to a number of highly publicized reporter subpoenas, the California legislature has adopted procedural mechanisms under state statutory law designed to confer greater protection from reporters. While most states offer a law to protect reporters from revealing their source, The Reporters Commission for Freedom of the Press was created in 1970 at a time when the nation's news media faced a wave of government subpoenas asking for reporters to name confidential sources. An example would be the co-founder or New York Times reporter Earl Caldwell was ordered to reveal his sources in the Black Panther organization to a federal grand jury, threatening his independence as a news gatherer. Caldwell's dilemma prompted a meeting at Georgetown University to discuss the need to provide legal assistance to journalism with their First Amendment rights come under fire. California Public Records Act, or the CPRA. The California Public Records Act was originally enacted in 1968. It regulates that governmental records be made accessible to the public upon request, otherwise exempted by law. If an agency receives a request to inspect an identifiable, disclosable record, the agency must promptly make the record available. Requests for copies of identifiable, disclosable records must be responded to within prescribed periods and must also be promptly made available for anyone who pays the applicable agency duplication costs or the applicable statutory fee. If an agency improperly withholds records, a member of the public may seek a court order to enforce the right to inspect or copy the records sought and may receive payment for court costs and attorney fees if such person prevails in the lawsuit. Here is another note on absolute privilege. Public officials, including law enforcement, can make statements in the course of their official duties without fear of being sued for libel. This is extended to also include court and legislative proceedings, public and official meetings, and contents of public records. Here's an example. In a courtroom, journalists have absolute privilege to report whatever is said by anyone there, whether they are witnesses, defendants, a judge, or member of the public. And at public meetings, including council meetings in Parliament and press conferences, journal also have qualified privilege. As a member of the media, you have qualified privilege. You may print defamatory statements made by people who are absolutely privileged as long as you are being fair and accurate, and the information is from a public proceeding or public record. However, if your report contains errors, you could lose that qualified protection privilege. If during a public meeting a city council member calls another member a crook, you may print the accusation. If the same city official makes the same comment to you during a telephone interview or after a meeting, you can't print it without risking libel. The key is the defamatory statement must be made in an official capacity. That wraps up our lecture on digital media law, and I will talk to you all soon. Thank you.